Hello, good morning, and welcome to this online event brought to you by the Dutch Permanent Representation to the EU, entitled The Digital Services Act, Redefining Hosting Services and Content Moderation Responsibilities. My name is Samuel Stolton, and I shall be moderating today's session. Today's webinar will consist of two parts. In part one, we'll hear about a couple of studies on the Digital Services Act, commissioned by the Dutch Ministry of Economic Affairs and produced by the consultancy Ecorys, as well as Radboud University. And part two features a panel discussion on the findings in these studies as part of a session, and for this we shall address two specific statements to be responded to by the panelists concerning monitoring of online content and internal complaint handling procedures within the Digital Services Act. As always, you can get involved with today's conversation by posing your own questions to the panel using the Q&A functionality on the platform, and we shall pick them up as they come through. Just to let you know that this event is also being live streamed on Twitter, so feel free to join the debate there too. And a recording of today's session will also be made available a bit later on YouTube. So without further ado, we are rather pressed for time, so let me introduce to you to formally open today's session, Director General for Business and Innovation at the Dutch Ministry of Economic Affairs, Focko Wijselaar.
Thank you very much, and good morning, ladies and gentlemen. I'm delighted to welcome you all to this webinar to exchange views on the Digital Services Act. It has been over a year since we were all hit by the COVID pandemic, a crisis that has definitely proven how crucial the internet, e-commerce and platforms have become to our economies and societies. We access information online, we shop online, we gather, meet and organize online, like today's webinar, and we connect with friends and families online. It's hard to imagine how the past year would have been without all these services. But we will eventually overcome the COVID pandemic. But it's my strong belief that the central position of the internet, e-commerce and platforms in society will remain. Over the past 20 years, we have seen the emergence and evolution of these services. The previous framework, the e-commerce directive, being innovative at its time, has largely proven a major success in enabling and facilitating all of these innovative services in the digital economy. At the same time, we have witnessed new challenges and risks arise from the use of these services, such as the dissemination of illegal content, crime, or the use of platforms for coordinated disinformation campaigns. To foster further innovation, growth, and competitiveness, we have to update the regulatory framework to ensure a safe, predictable, and trustworthy online environment where fundamental rights and European values are respected. We therefore welcome the Commission's proposal for the Digital Services Act and compliment her efforts. The proposal is of a high quality already. Nonetheless, in preparing for the Digital Services Act, we have commissioned two studies that feed into our evaluation and contribution to the proposal. The first study was meant to inform us on possible ways of redefining all the services that have been placed under the category of hosting services. This will enable a more granular approach when defining the responsibilities of hosting service providers and the various e-commerce and other sorts of platforms. The second study was meant to inform us on how a system to combat illegal content online would ideally look like, taking the existing legal frameworks, such as the e-commerce directive, as a basis. This advice will help us contribute and refine the European Commission's proposal. Before I hand back the floor to our moderator, I want to emphasize that we are still in the process of assessing the recommendations that will be presented to you in a moment. We have not yet taken a position regarding these recommendations, so the views of the speakers are not those of our government as yet. We will take all of today's valuable feedback from you and the panelists into consideration. So it's really an open debate, and it really helps us to form our position. If after this webinar you would like to further discuss the studies, the recommendations, or the DSA proposal, then please reach out to us. Our door is open. Thank you.
Thank you very much, Foko, for your opening remarks there. I really like this idea of open democracy and engaging with stakeholders before you've adopted your position. So hopefully today's session will give the Dutch many insights with regards to your future stance on the Digital Services Act. We move on now to the presentation of our first study, and this presentation will last around 10 minutes, and it is brought to you by Olga Batura from Ecorys.
Yeah, good morning, and thank you for the opportunity to present the results of our study. First, I would like to briefly remind you what the assignment of the study was. It was to re-examine the definition of the hosting services under Article 14 of the E-Commerce Directive and to work out a logical taxonomy or classification of such services and to see what policy implications this might have. So based on desk research and interviews with stakeholders and experts, we formulated 5 important characteristics that such hosting taxonomy needs to exhibit. The taxonomy needs to apply to hosting. The taxonomy needs to apply to services, not providers. It should be robust against time. It should be inclusive and comprehensive with regards to services it encompasses, which plays into robustness. And it should be technological neutral, which also is important for it to remain robust. So what we came up with is the taxonomy of services that you can see on the slide. Let me explain it in more detail. We suggest 2 main categories of hosting services based on what main function the service fulfills. In category 1, we have services whose primary and often sole function is to store and provide content of third parties. In category 2, we have services that store and provide content of third parties in support of or as a necessary step in the execution of their primary function. For example, the main function is to match sellers of books with buyers of books, but hosting of the content is a necessary operation to serve this main function. At first glance, this classification seems similar to the distinction suggested in the DSA proposal, which differentiates between hosting providers and hosting providers who are online platforms. But this is not entirely the case. Our taxonomy does not draw on the business model or size of a provider because these characteristics can change fast and therefore are not robust against the time. Let me explain a little bit more each suggested category. Category 1 services, we consider classical or similarly straightforward hosting services. They would include web hosting or cloud hosting, as well as services of data or content storage, such as provided by OneDrive or Dropbox or RapidShare or similar providers. We note, however, that these latter services of data content storage are a subset of cloud services, but we identify them into a separate subcategory because of a larger content control power that the provider may exhibit. In addition to having primary function of storing and providing content, Category 1 services are typically characterized by limited access to the content stored and therefore knowledge of such content. The host may know who is storing the content, where it is stored, how large it is, what types of files are stored, and some other metadata about the content. However, the host does not have detailed knowledge of what the content is exactly and does not use this metadata to provide other services to the user. This limitation is often a technological one due to the levels of encryption applied. We mentioned that data storage services like Dropbox may have higher levels of content knowledge, which usually depends on the business model applied. To give you an example, the terms and conditions of iCloud by Apple reserve the right for the Apple to screen, move, refuse, modify, and/or remove content at any time without prior notice and at its sole discretion. Other providers of similar services, such as, for instance, Freenet or TrustRead, do not do this. So it's a business model choice. Lastly, Category 1 services are the necessary basis for the existence of Category 2 services, although sometimes it is not immediately obvious. Now, Category 2 services, they are more sophisticated. Their primary function can be almost anything, but storing and providing content is necessary to fulfill this primary function. Category 2 services have to process the third-party content in some way in order to fulfill their primary function. By processing, we mean content curation, filtering, tagging, and other types of content management, as well as extraction and analysis of metadata related to this content. And this leads me to the third characteristic of Category 2 services. They rely increasingly heavily on the processing of metadata from users. So to give you an idea of Category 2 services, we also subdivided them into several subcategories based on their primary function. Our subdivision is fairly high level, and a different subdivision can be suggested, again, based on the main or primary function. So our subdivision is indexing and referencing services, content aggregation services, publishing, connecting different people around networked interactions. This last subcategory is very broad and spans different interactions from networking to collaboration to gaming to different types of commerce. So now what does this mean, this classification mean in terms of possible policy options? We see three main options. First, next to the existing categories of mere conduit, caching, and hosting, a new fourth category could be introduced, called, for instance, Hosting Plus. It would cover those services that have as a primary function not storage and provision of content by third parties, but that rely on the storage and provision to fulfill their main function. Second option, we can keep the current categories, but split hosting into classical hosting and Hosting Plus along the lines suggested by us. Third option means a more dramatic change. So it would require to rethink or update the knowledge and action standard that is currently used. Policymakers could also analyze the characteristics of modern services of mere conduit and caching to see whether a different knowledge standard could apply to them as well. And this whole exercise could lead to creation of two completely new service categories in the legislation based on the knowledge standards. For example, one category could be services that have limited control over the stored content, possibly includes mere conduit, caching, and classical hosting. And another category of services could include those whose functions mean that activities of the provider make it much more likely to obtain meaningful knowledge about the content stored. We also suggest a fourth policy option that is not independent but builds on the policy options suggested before. Within the broad categories of the taxonomy, policymakers could make even further breakdowns into subgroups or analyze services on the case-by-case basis. This would depend strongly, of course, on the regulatory purpose. For this analysis or subdivision, policymakers could use relevant factors that we did not use to define our main taxonomy, but these factors could be relevant for the specific regulatory purpose. To give you an example, as I said, we did not base our taxonomy on the size of business model or the provider. However, these characteristics may be a justification for a different standard of due diligence with regard to harmful content. For instance, business models based on promotion of certain content like disinformation or sexual child abuse could be linked to denying the ability to rely on the safe harbor exemption. This fourth policy option is similar to what has been introduced in the DSA proposal. Articles 17 to 33 of the DSA proposal introduce additional provisions or obligations for hosting service providers who are online platforms. Well, this concludes our presentation on the possible classification of hosting services and policy implications of that, and we're looking forward to your comments and questions and to the fruitful discussion. Thank you very much.
Thank you so much for your presentation there, Olga, and thanks again for keeping it within the 10 minutes time frame, which is very useful for us as well. Some fascinating insights there on the taxonomy of hosting services, particularly interested by this bifurcation between classical hosting services and hosting plus services. So perhaps that's something that we might be able to raise again a bit later on. We're going to segue now into our second presentation of the morning, and this comes to you from Pieter, Wolters and Raphaël Gellert from Radboud University, who have around 12 minutes to present their findings.
Thank you, Samuel. So the most important question in our report was the last question. How can new rules best encourage hosting service providers to limit the dissemination of illegal online content? We formulated several recommendations that all fit into 4 themes. First, despite the fact that the e-commerce directive is 20 years old, many aspects are still unclear. This is why we recommend to clarify the framework in several ways. Next, the current framework is fragmented. There are many rules imposed by vertical instruments, but they only apply to certain types of illegal content and certain types of hosting service providers. We recommend to harmonize this framework when possible. Furthermore, we recommend to codify self-regulation and existing practices into binding law. And finally, we recommend increasing the protection of the various involved interests. Hosting service providers should have more obligations to act against illegal content and to protect fundamental rights. With this introduction out of the way, let's start with the recommendation on the core principles of the European framework. There's a relatively strong consensus that these principles are sound. At the same time, there are still unclarities, even after 20 years. We therefore recommend to clarify them. The exemptions from liability should be maintained. However, a Good Samaritan provision should be included to make it abundantly clear that hosting service providers can moderate their services without losing the benefits of these exemptions. Next, the exact meaning of actual knowledge and awareness and expeditiously should be harmonized and clarified. Unfortunately, the DSA proposal only provides very limited guidance in this respect. Similarly, the DSA proposal does not clarify the prohibition of general monitoring obligations. In any case, it should be clarified that a notice and stay down obligation is allowed as long as it can be performed automatically. One can wonder whether this is enough though. Hosting service providers are still frequently used to disseminate illegal information. We recommend that they should also have a duty to proactively monitor publicly available online content. We understand that this is a controversial recommendation and that it is not included in the DSA proposal. We look forward to the discussion at the end of the session. But for now, we would like to stress that it is not as revolutionary as it may sound. First, proactive monitoring obligations are already imposed for certain types of illegal content by both law and self-regulation. It makes sense to equalize the situation for all kinds of publicly available online content and for all hosting service providers. However, these obligations should not be too strict. They should only require monitoring that can be done efficiently through automated tools. Such monitoring is already done anyway. The obligation as we recommended would not force everyone to do more. It is primarily targeted at hosting service providers that are lagging behind. We want them to catch up. Finally, the current framework is very much focused on the core. Many important issues, such as notice and action mechanisms, are not regulated. They are left to self-regulation, national law, and vertical instruments. We recommend that important rules like this should be included in binding horizontal European law. Self-regulation can and should be used to flesh out the. Furthermore, we recommend the harmonization of the liability. A hosting service provider should be liable if it hosts illegal content and the exemption from liability does not apply. It should also be liable for violating monitoring obligations or other obligations designed to prevent the dissemination of illegal content. Next, the primary tortfeasors, the users, should also be liable, and it may also help to harmonize and clarify the illegality of online content whenever this is possible. Unfortunately, all of these recommendations are not included in the DSA. The liability is not harmonized at all. Raphaël.
Thank you, Pieter. And now I'm going to talk about more specifically about the notice and action mechanism and other procedural mechanisms. And so in our report, basically, we noticed that there were gaps at this level in terms of a lack of harmonization and a lack of agreement of what constitutes an adequate notice mechanism. And this also led to a lack of adequate protection for victims of illegal content online. But it also proved to be very resource intensive for hosting service providers. And for this reason, we have made recommendations that can be framed in terms of clarification, harmonization, codification, and increasing the protection. And therefore, this leads us to recommend that there should be a harmonization and a standardization of the notice and action procedure throughout the EU and for all kinds of illegal content. And so, in other words, we see the DSA as a baseline in terms of what constitutes a valid notice and action mechanism. And we also recommend that this be extended to all hosting service providers. Now, naturally, this is a very general recommendation that can be subdivided into more specific, more granular recommendations. But here, unfortunately, for lack of time, it's not possible to delve into all of them. So I will just mention, for instance, that we emphasize the need to have good safeguards against abuses of the notice mechanism or the obligation for hosting service providers to act diligently on all the notices that they receive, so both founded and unfounded. And I would also like to point the attention also on our recommendation on the trusted flagging system. So, of course, we recommend, like the DSA, a trusted flagging system with particular emphasis on the harmonization of the attributions of the trusted flagger status and on the prevention against abuses. But we also diverge from the DSA on a number of points. So, for instance, we extend this obligation to all hosting service providers. We also recommend that the DSA clarify what the status of existing trusted flaggers would be, because right now the DSA is about creating a new certification mechanism, but it doesn't say anything about, well, what the situation would be for those already existing trusted flaggers. And finally, we also recommend to implement a so-called non-discrimination provision. So that is for hosting service providers not to unduly favor one trusted flagger over another. And this is also currently lacking from the DSA. Moving on, we also make recommendations in terms of redress mechanisms. And here the gaps that we observed are lacks in terms of a lack of harmonization, high costs, and a lack of agreement on what are actually adequate redress mechanisms. And for this reason, we make recommendations in terms of harmonization, codification, and increasing the protection. And this means that we recommend that there should be a quick internal complaint handling mechanism. And here, already maybe a bit teasing the discussion later on. So the way that we see this internal complaint mechanism, we really see it as very close to a counter notice mechanism, except that it's ex post. And so this means that we really see it much closer actually to a notice mechanism rather than a sort of court mechanism. And so this means that it should really be closer, and the submission of counter notice should be facilitated in the same way as that of notices. And of course, it can't display all the fair trial safeguards that one would expect from a normal court. And finally, we also recommend that there should be an out-of-court redress mechanism. And here, in our recommendations, we broadly agree with what the DSA says, but we think that there could be some clarification on a few elements, such as costs, language, or delays. And we also extend it to all hosting service providers. So, Pieter, I give the floor back to you.
Thank you. So another issue is that the way hosting service providers practice content moderation is not always clear. For this reason, we recommend reporting obligations about the content moderation, both in accordance with terms and conditions and self-regulation, and in accordance with the law. Now, of course, this does impose some burdens on the platforms, especially because there are so many reporting obligations. We therefore recommend harmonizing and standardizing them as much as possible. Unfortunately, this is not really done by the DSA proposal. It leaves existing reporting obligations intact. Finally, the obligations should be tailored to the risks that are caused by a hosting service provider. Generally, platforms can cause additional risks because the content is provided and disseminated by the users. For this reason, they may be subject to more stringent obligations. However, as Raphaël discussed, we think that most obligations should also apply to all hosting service providers. Next, online marketplaces cause immediate financial risks. They can be used by sellers to commit fraud or sell junk products. For this reason, we recommend that online marketplaces are subject to a Know Your Customer obligation. The DSA proposal contains such an obligation, but only for professional traders. We recommend that this is extended to all sellers. Finally, the size of a hosting service provider can have an influence on the risks. However, even smaller hosting service providers should be subject to obligations in relation to individual pieces of illegal content. In contrast, they may be excused from obligations that are designed to protect fundamental rights and freedoms or the society as a whole. Such obligations are more important and should be more stringent in relation to very large online platforms. Thank you very much. Samuel, the floor is yours.
At Radboud University there, some bold proposals there. I mean, particularly with respect to this idea of imposing a duty of proactively monitoring publicly available online content. I had flashbacks to the Copyright Directive debate just as you were speaking there, Pieter. But thanks very much for your contribution. We're going now to move on to the panel session of today's event, and joining Raphaël and Pieter here, we also are very pleased indeed to have with us Renew MEP Karen Melchior and also Irene Roche Laguna from the Commission's DG Connect. Our panelists will be responding to two statements that have been prepared in the context of the findings of the studies. And just a reminder as well that you are invited to submit your questions to us using the Q&A functionality of the platform. I can see there's some coming through now. Let's keep them coming. So perhaps we can start with statement one. And the motion that we have here is that hosting service providers should have a modest, in brackets, duty of care to proactively monitor publicly available online content, something, of course, not currently in the DSA. So perhaps to start us off here, we could turn to the Commission and, Irene, get your response to this motion.
Yes, thank you very much, and thank you for the study. From the first place, the Commission always welcomes these studies that can feed also on the discussions. On this first statement, this was something that we considered under the preparation of the DSA, but obviously any general obligation to proactively monitor and capture illegal content could have a negative implication on the prohibition of general monitoring obligations. And there, the court has been clear that this is acceptable for court injunctions in certain circumstances, but not as regards notice, for instance. So this was something that was discarded, and also because it does not create the necessary legal certainty. If you ask, if you impose an obligation to do something, to be proactive, the service provider does not know exactly when it did enough, and also what will happen if something escapes this proactive attention. So it values zero in terms of legal certainty, and this is also why it was discarded. If I understand the concern for services which lag behind, as you said, in terms of structurally cooperating with infringement or with criminal actions, but these services are already today excluded from the liability exemption. Already the e-commerce directive excludes the service that deliberately cooperate with the infringement, and the DSA has included the same idea under the recital 20. So we do not see that risk, and we think that the consequences of adding such a modest duty of care could be rather negative.
Okay, thank you very much, Irene. Negative consequences there to the modest duty of care. Karen, perhaps we could get your response to this before turning back to Raphaël and Pieter.
I would be quite skeptical about this. It is too much similar to the Good Samaritan clause as well, and I think it would be in contradiction to the ban on the general monitoring. I think a remark by the last study was that automated monitoring, which would be done effectively, could be put in place. And this is slightly similar to this statement. And what the problem for me is that this cannot be put in place effectively. You can't have automated monitoring that is effective because you lack the human touch, you lack the understanding of context. I think if we want to encourage the platforms to monitor content on their platforms more actively, I think this should more be done by design, and also the notice and action measures that we already have and the trusted flaggers, because there you can have input on problematic content seen by humans that understand the content, and not by using a phrase from the copyright directive debate, upload filters, in order to do that.
Okay, thanks very much, Karen. I'd like to turn back to you now, Pieter, just to respond to those responses, and perhaps also in the context of a question that's come in from Matthias at AWO, with regards to the points raised by Irene and Karen on the idea of this proactively monitoring publicly available content and how this might conflict with a ban on general monitoring. So perhaps, Pieter, I could get your response to that and your thought process in terms of the potential conflicts at play there.
Yeah. So first to clarify, a proactive monitoring obligation would of course mean that the ban on general monitoring obligations would be softened in this respect. It would be harmonized. That yes, they do have an obligation to proactively monitor, to generally monitor, but this is one that is harmonized. So in this light, yes, of course there's a conflict. We can't have them both. However, we would recommend that does mean that member states would be prohibited from imposing further obligations than those that are harmonized by the DSA. Second point was about legal certainty, and you are certainly right. An obligation to proactively monitor would, of course, lead to certain legal uncertainty, but well, that's the nature of law. That's the nature of general clauses. That's the nature of duties of care, and this would hardly be only the case for a duty to generally to proactively monitor. I don't see this as a problem at all. It is a part of all directives, regulations, and all national law. However, a problem in this light is, of course, that the history with this issue is diverging within in Europe, and it was necessary for the Court of Justice to provide some harmonization. This could be dealt with by formulating a general proactive monitoring obligation in a little bit more precise way. And again, I think that a notice and stay down obligation could be precise. And yes, we would go back to the copyright directive in the digital single market. This is hinted at as something that is negative, but at the same time, we are already doing it for copyright. So apparently, there's not a major issue preventing this. We could also do this for other kinds of illegal content. Thank you.
Okay, perhaps I could bring Irene there to respond to that, because there are a couple of points on the copyright directive in particular that I think need to be clarified there. Irene, if you could step in and respond to Pieter's comments there.
Yes, thank you very much for these points. First, the copyright directive is a sector-specific instrument. It was a very difficult negotiation, and we came, the co-legislator came to the agreement that the services that are covered by the scope of the Article 17 are not intermediaries in the sense of Article 14 of the e-commerce directive, because they communicate to the public. So they commit an act of communication to the public themselves. It's not about someone else's infringement, it's their own infringement. So the situation is different, and we cannot say because it works in copyright, it can work also for other types of illegal content. But even for copyright, a notice and stay down obligation as such does not apply. It is a cooperation between the service provider and the rights holder that has to provide the necessary information. But just to go back to the DSA is horizontal. It applies to all types of illegal content, and it would not be the best place to impose such a general duty of care to generally monitor content, whatever type of illegal content, and with unknown consequences. Let me put the example of spam filters. Spam filters are voluntary. They are not imposed. Imagine today we come with an obligation to filter spam in our email accounts. Then service providers would err in the side of caution, because they don't want to make mistakes, because mistakes would lead to legal consequences or financial or claims for damages. So they will filter anything which could potentially be spam, instead of elaborate and work on innovate on filters that can identify those emails that we do not want to see in our inbox.
Okay, thank you very much, Irene there. Just to come back to the point on proactive monitoring and upload filters within the copyright directive, a lot going on at the moment here. Yesterday we saw the Italians implement the copyright directive into national law. We've obviously got the Polish complaint to the Court of Justice coming up in July now, but the transposition deadline, of course, is June the 7th for the copyright directive, and the Commission, we're all waiting really for the Commission to issue guidance on Article 17. Is there anything you can tell us, Irene, about when we can expect that to come?
It will be published in the weeks to come. There is not much I can say about that.
Okay, and do you expect that maybe to influence the debate here with regards to proactive monitoring for the DSA?
No, honestly, as I said before, I think these are separate issues, because the situation is different. So we should not bring or spill over the effects of Article 17 into other types of illegal content, because it's very content specific.
Okay,
we have
great.
The example of the terrorist content proposal, where the Commission came with such a duty of care, and the Parliament and the Council agreed not to include it. So this shows that it is very much content specific.
Yes, absolutely. We are rapidly moving on at the moment, so we'll have to jump on to our second motion of the day. And the statement that we have in front of us is that the obligation to provide for an internal complaint handling mechanism should apply to all hosting service providers. Karen Melchior, what's your response to this statement?
I think it will place quite a burden on small platforms to have such an obligation. However, I do think that fundamental rights and the respect of these is important, no matter the size of the platform. But how this is done needs to be proportionate with the size of the platforms and the capacities that they have. I'm not quite sure if there is a possibility of perhaps outsourcing this to user, like you have consumer ombudsmans that assist with things concerning consumer rights. But I think it's important that we don't give small platforms just a free pass. However, the necessity for an internal dispute settlement needs to be adapted to the size of the platform.
Okay, thank you very much. Irene, would you like to respond to this statement? The obligation to provide for an internal complaint handling mechanism should apply to all hosting service providers.
Yes, indeed, I agree with Karen in this point, and this was an assessment that we conducted under the impact assessment. And at the end of the day, the question was whether it was proportionate and necessary to extend this obligation to all hosting service providers. We came to the affirmative for notice and action procedures in Article 14 and 15. The statement of reasons applies to all hosting service providers because we think this is the very minimum obligation that a hosting service provider, even the classical hosting as you say, and ancillary services have to put in place. But we thought that further measures that act as a bit as a consequence of that notice and action would be disproportionate, either for smaller services, smaller hosting, but also to those that are only an ancillary service. For instance, the comments section in an online newspaper. We think that this is a hosting service, but then imposing a burden of having a full complaint handling mechanism would be disproportionate. Or also the review section in an online web shop. You can put your comments there, and it is a hosting service, but probably a complaint mechanism would not be absolutely necessary. And the same with web and cloud hosting services, where contractual relationships apply and will probably also give a solution to that aspect.
Thank you very much there, Irene. Raphaël, could I bring you... Yes, Karen, yes. If you jump in quickly,
Thank
then
you.
we'll turn back to you.
I find it a little bit problematic to exclude, for example, the comment sections on newspapers completely from a complaints handling mechanism, because this is sort of I think they have an obligation to deal with comments on their papers, and they would have to hire enough staff to do this to make sure that it's done properly.
Okay, interesting proposition there. Thanks, Karen. Raphaël, could I get your response to the points made by our panelists, please?
Yes, absolutely. And thank you for the responses. And first, I would like to emphasize that I fully agree with you on the issue of resources. And that's why the way that we envisage the internal mechanism, complaint mechanism in the report is a very specific one, where we say that it's basically a sort of equivalent of the notice mechanism, except that it's ex post and that it should be very quick. So we say, for instance, so the content providers have 14 days to respond. And so the logic is really to make it a sort of equivalent notice, except that it's ex post. So it's much closer to the notice mechanism than to a sort of internal court, if you will. And so the reasoning is here that if a hosting service provider has enough resources to put in place a notice mechanism, then it should have also enough resources to put in place this sort of ex post counter notice mechanism. So here, this is really how we envisage, and we also agree that use of automated tools should be possible as long as as long as the decision is not fully automated. And in this way, this sort of notice mechanism can also, well, function as a sort of, a possibility to have a human intervention in case there are, for instance, automated decision taken on notices. So it's really closer to a notice mechanism than what we currently imagine as an internal complaint mechanism.
Okay, thank you very much for your comments there. We have some questions coming in through the audience. And we have one here from Xavier, who asks about this point in particular with regards to the size of the platforms and their capacities to deal with notice and takedowns. Xavier asks, sellers of counterfeit goods often flock to the smaller hosting providers because they will not have staff to enforce a proper NTD policy. Excluding smaller hosting providers will necessarily cause an increased resort to court action. Now, that's an interesting point, and kind of this chimes a lot with what Karen was saying a bit earlier on. Perhaps, Irene, you would like to respond to this question.
Sure. This is something that has been discussed in particular because in the DSA we are focusing and proposing particular obligations for very large online platforms, and then for online platforms where small and micro platforms would be excluded, not the medium ones. So we are going beyond the recommendation on SMEs, precisely to avoid that situation where illegal content could, as a consequence, move to smaller platforms. But on the other hand, it is always a check and a decision to be made in terms of proportionality. If we wanted to avoid that any particular piece of illegal content moved anywhere, obviously it would be enough to extend all the obligations to all services providers in Europe and across the world. Then maybe the problem would be solved, but it might be disproportionate. And also, we do not want to hinder disproportionately the smaller platforms that we want to appear and grow up in Europe. So obviously it is an exercise of balance to be done, and if the content in the example of counterfeit moves to smaller platforms, then there are the means. This is also why we have kept notice and action applicable to these smaller platforms. And there will be means, also orders, they are always available to attack such content. But because of the size of that company, we infer that also the impact will be smaller.
Okay, thank you very much. Karen, what's your take on this idea that, should there be more robust obligations on the larger platforms in terms of notice and takedown procedures? And we see this migration of illegal content, which, by the way, is already happening to the smaller platforms. What kind of challenges does that present to us from a regulatory standpoint?
I think we need to look at the risk that each platform represents as well. In terms of the legal content, if you look at the risks that, for example, a platform as WhatsApp posed to when it was still an independent platform, this was not in direct correlation with the size of the platform, its turnover, or its amount of employees. However, the question, I think, relates a little bit more to transactional platforms. I've heard a taxonomy of platforms distinguishing interaction platforms and transaction platforms, which I find is quite interesting. And here I think we could impose more strictly the know your business customer obligation, and also make use of already existing business registers in the member states, and perhaps even look into having a European-wide business register so that the platforms have easy access to control who their customers on the platforms are, who are selling physical goods or renting out flats or something.
Okay, thanks very much, Karen. I just wanted to follow up on your point there about the know your business customer principle, because we have a question here from Patrick. And Patrick asks, is the Know Your Business customer principle for platforms a realistic demand when other sectors like banks are already struggling to meet these demands?
I think it is a realistic demand, and I think that we have quite success with this in Denmark regarding hosting of websites, where DK Hostmaster has in Danish legislation a requirement of knowing who it is that is behind each domain, and that has actually prevented the sale of counterfeit goods in Denmark on Danish websites. So I think it is possible, and I think it's a very good way of dealing with illegal products and counterfeit goods, because it makes the seller more responsible and easier to access, and I think it could prevent some of the sales which filters will not be able to do.
Okay, thanks very much, Karen, for the clarification there. We're getting in some questions here thick and fast, and I want to bring them in as much as I can. Going back, obviously, to our earlier discussions on the general monitoring obligation and to proactively monitor online content, we have a question here from Vivian Witt from ITI. And this is a question for Pieter or Raphaël. How do you take into account fundamental rights and safeguarding freedom of speech in your research and the deriving recommendations? A general monitoring obligation and stay-down orders are not the right way. This is there is a major difference between copyright violations and other types of illegal content online, and you cannot compare them both. Perhaps this is one for Pieter to respond to.
Yeah, the most important reply would be that these recommendations, they should be viewed as a package. So we do recommend much more stringent, or well, not that much more, but more explicit recommendations to combat the dissemination of illegal content. But at the same time, we also recommend safeguards for fundamental rights. So the one should always go hand in hand with the other. If content is removed unjustifiably, then the users, the uploaders, should have a recourse first by internal complaint mechanism, then out-of-court settlement, and always the option, out-of-court mechanisms, and always the option to go to a court. So I think it's very important that they should be viewed as a package. Another thing that is important is that the e-commerce directive has applied for 20 years, more than 20 years. We should not forget that what is possible now is that content moderation now is much more advanced than it was 20 years ago, and it will be even more advanced in another 20 years. We do, of course, see that there is a risk of over removal, but this risk already exists. This risk also exists with notice and action mechanisms. If there is a notice and action mechanism and there's a notification, hosting service providers can be nudged to err on the side of caution. And for proactive monitoring obligations, we think that this is an obligation to perform proactive monitoring obligations. We would not state that every piece of illegal content that is not found through proactive monitoring obligation means that there is actual knowledge and thus liability. An obligation to perform proactive monitoring obligation should not mean that you are liable whenever something is missed. So I hope this can alleviate some of the concerns.
Yeah, I'd like to bring in Irene here again just to respond to some of those points you made there, Pieter. I could see Irene. I don't think she's convinced by your argument, but let's see. Do we have this risk of over-removal of online content as it stands, Irene, as Pieter just said?
I think there is the risk of over removal, and across the whole instrument that we have proposed, we have included all necessary checks and balance and stop from imposing such general monitoring obligations. But also we need to bear in mind that the majority of content which is removed today is not removed because it's considered illegal. It's removed because it's considered against the platform's terms and conditions. Then the situation is different. And this is why in the DSA, we are asking all services providers that engage in content moderation, so not only platforms, to be transparent on content moderation measures and to be consistent, to avoid arbitrary decisions, which are also a main source of over removal. Also, that covers the situations where a filter finds content that is clearly not against terms and conditions or not clearly illegal, and it's nevertheless removed. So we are increasing the rights of the users, and fundamental rights is a main objective followed by these main provisions under the DSA.
Okay, great. Thank you very much, Irene, for your response there. I'm conscious of the fact that we're rapidly running out of time, unfortunately, as with all of these things, we need a lot more time to discuss the ins and outs of the Digital Services Act. Before we sign off today, though, we have a closing statement from Helene Ud de Haag, Deputy Director at the Ministry of Economic Affairs. Helene.
Thank you, Sam. It was a challenge to have a discussion within 1 hour on such a complex item, but it has been a pleasure to hear this exchange of views and to also hear all the valid points made by the speakers. So I would love to thank the speakers in this webinar. Today's discussion really highlights the responsibilities of the intermediaries. And we need a framework that fosters trust in the online world, but also to let our companies grow in this upward trend of digital services. So we take back these contributions of today, and they're very valid. And we thank you all for participating in this webinar, and thanks again to the speakers. And we would love to see you participating in a future webinar as well. Thank you very much.
Thank you very much there for your closing remarks, Helene, and some of the contributions we've spoken about today, this idea of proactively monitoring publicly available content, and should there be such a duty of care imposed within the DSA, I'm sure will feed on as the ongoing interinstitutional discussions continue. But of course, there are a lot of work to be done before then in the Parliament and in the Council working parties, although progress has been good from what I understand in the Council. A big thank you to all of our panelists for taking the time to join the discussion this morning. Thank you to all of you for tuning in remotely for this session and for your contributions and questions. I'm very sorry indeed we didn't have the opportunity to get through all of them, but perhaps this is an indicator that we need a few more of these flash sessions to discuss the ins and outs of the Digital Services Act. And finally, a big thank you to the Dutch Permanent Representation of the EU for hosting today's panel. Thanks again, and we'll see you in the not too distant future. Thank you.